Hi, everybody. I've been asked to talk to you about patentability of software. Um, so just before we kind of get into the substance of the talk, as John said, my name's Phil. There's my email and my LinkedIn details if anyone's interested in getting in touch. And also, as mentioned, I'm a patent attorney. I don't know how many of you have come across patent attorneys before. Um, But we essentially have technical backgrounds. We're not kind of lawyers in the traditional sense. So I don't have a law degree. I actually have an engineering degree, and then we study the law subsequently. And we typically tend to fall into the area of patent law in which we're trained. Although originally I've got an engineering degree, I tend to deal with a few software patents now, in addition to engineering type patents. So you can kind of look at us, I suppose, as a weird mashup between Brunel and Judge Judy, if you like. The kind of things that I'm going to talk to you about this evening. So, first of all, I'm going to go through what is a patent. Appreciate some of you may have had some experience with patents before, not necessarily everyone. So, I'll kind of take a quick run through what they are, why we want them. One thing you can certainly say about patents is they're expensive. They tend to cost quite a lot of money, both to get granted and to litigate. So, why? What's the driving force behind that? I'll then talk a little bit about patentable inventions, what makes something patentable or otherwise. And then we're going to talk a bit about whether we can patent software in the UK and the European Patent Office. Both of those jurisdictions are important. Obviously, the UK because we are in the UK, but also the European Patent Office because it covers the UK as well. It's kind of EU plus some other non-EU countries. So we always have been, part of that European patent project and continue to be as well. So it's an important area to be aware of. Um, and then I'm going to talk a little bit about AI. I don't know if you've read in the news recently, but there's quite a significant case that has gone up to the Supreme Court on the patentability of AI, and then a few kind of conclusions at the end. And if you have any questions, obviously feel free to, I think, put them in the chat box, and I'll try and get to them when I finish kind of going through the presentation that I've got. So, what is a patent? This is kind of the government's definition from the UK government website. So essentially, it's something that can help you if you want to take legal action against someone who uses your invention without your permission. So, for example, if they sell or manufacture your product in the UK, and that's kind of the very traditional view of what a patent is and what you would do with it. And this kind of implies that a patent is all about a thing, an object, a widget, if you like. But it's important to note that patents also cover methods, particularly with respect to manufacturing processes, but also with respect to software. So you'll see when we come on to some examples that patents often relate to a method of performing a task involving several steps, and obviously those steps can be carried out by a computer in the form of software. And this is probably how I would define a patent, which is really fundamentally it boils down to a legal right to exclusively use a patentable invention for a limited period in exchange for publication of that invention. So, on the one hand, the invention to a patentee, so the person that invents it or a company that employs that inventor, is that they get a monopoly over their invention. Only they can use it for a certain period of time, which is 20 years from filing pretty much the world over, assuming the patent gets granted and stays in force. And in exchange for doing that, they agree to publish the invention. All patent applications are published and all patents are published. So essentially, you're saying, I will give this information to the world in exchange for a monopoly on it. And obviously, once that patent expires or it's abandoned, then anyone is free to go and use that technology. And the idea is that it stimulates invention by encouraging companies and encouraging inventors to go out into the world with their new products and their new inventions, because it reduces the fear that they're simply going to be copied. They have some protection in place. So therefore the kind of the whole industry of innovation is stimulated. So what does a patent really protect? Well, patents are, I don't know if you've ever had the pleasure of reading one. They're quite dull documents, to be absolutely honest with you. But what you'll find usually at the back of a patent document is a kind of a numbered series of clauses called claims. Um, and they really define the scope of protection that you get with a patent. And what you'll typically see is something having features A, B, C, interacting in a certain way. And if that patent is granted and someone else makes, imports, uses something having features ABC working in that same way, they infringe the patent essentially. And it's anyone who's making, importing, selling, using something that falls in the scope of those claims would infringe that patent. Similarly, if the claim is all about a method, so a method of undertaking steps A, B, and C, then if they were to undertake that method in the jurisdiction, then they would also fall foul of the patent. So the claims are very, very important. And I've got a nice example of a claim here, which we are going to talk a little bit about later, but don't feel you have to read every single step of that. But you can see this is kind of a classic computer implemented invention, or CII. So you can see that there's a number of steps that's being carried out by a software program, which is controlling, it's receiving data in step B there, it's calculating something in step C, it's running a comparison in step D, identifying some points in an image at step E, and then modifying and outputting that image in step F. So quite clearly going through all those steps. So if this particular claim was granted and someone was to produce a piece of software which undertook those same steps, then that patent would be infringed by that software. And in terms of getting a patent granted, you can boil it down to this kind of very simple flow diagram. You typically take your invention, you would write a patent application, which gives a very detailed explanation of how you achieve that invention. From a software perspective, you don't normally have to put kind of code in or anything like that, but you would typically have something which shows how the process that the software carries out works in terms of a flow chart. And you would obviously have your claims at the back of that application as well. You may have some drawings as well. You would then submit that to the patent office, at which case you get an application number, and it's what a lot of people will refer to as patent pending. You have a pending patent application that has not yet been granted. At some point, that application goes through a process with the patent office whereby an examiner will kind of pick it up and basically assess as to whether it meets the requirements of the Patents Act in the UK or the European Patent Convention or wherever you filed it. And you may then go through a bit of a process with the examiner as to, they may send you an objection saying, okay, we're not too sure about this claim. We think it's been done before. And then, you either amend your claims to overcome that objection or alternatively argue the point. So there's a bit of advocacy involved at that point. And then, once the examiner's happy that it meets the requirements of the local patent law, wherever it is, and, once I'm happy as your patent attorney, or you're happy as the applicant that it's appropriate and it gives you good commercial protection, then the patent is granted. And the only real difference between having a pending application and a granted patent is you can't sue anyone for infringement until the thing's granted. So, bearing in mind this process typically takes several years. A UK patent may take 3 to 4 years to be granted on average, maybe a little bit quicker these days. But certainly patents elsewhere can take longer. The European Patent Office is a little bit slower. You don't be waiting until the thing's granted to commercialize your invention. Essentially, you can commercialize your invention once the application has been filed, so the first step, and then this process will run in parallel with you going to market and hopefully making a success of your invention. So patents are very much territorial rights. They kind of act like a fence around a country, if you like. So the two jurisdictions I'm going to talk about are the IPO on the left, which is the UK IPO. I should mention. I've put the Republic of Ireland on there, but it's obviously just Northern Ireland, the rest of the UK. Um, and also the European Patent Office, which is kind of an intergovernmental organisation which grants patents which cover, all of the EU countries plus a lot of non-EU European countries, and it can also extend. I think there's Morocco's part of that as well now. So, potentially it's also outside, potentially countries also outside Europe. Um, so, it's a significant area which the European Patent Office can cover. So really powerful, right, and a lot easier because you essentially get that whole examination process is done in English at the European Patent Office. It means you're not having to file individual patents in each country in Europe. So obviously it's a lot quicker and cheaper than doing so. So the next question is why bother with patents? And obviously, the main driving factor for a lot of people is, well, we don't want our competitors to copy our products. We spend a lot of money, a lot of investments gone into R&D, and the last thing we want is for someone to come along and simply rip off what we're doing. So that's the kind of the primary reason, and probably the most well-known reason for getting patents granted. And the way that you do that is through the courts. So if someone's infringing, you will do your best to come to some kind of commercial agreement with them, but ultimately the place where you can get an injunction to stop them from doing the infringing activity, performing the infringing activity, or potentially some damages, and a proportion of your cost back is in the courts, which is, to be honest with you, not many patent disputes end up in court for good reason. Court proceedings are very expensive, particularly in the UK. So it's something that's best avoided. But that's the ultimate kind of stick rather than carrot, if you see what I mean. So other reasons, and these are kind of more commercial, and to be honest with you, a bit more realistic in terms of what companies want to achieve, is licensing out the invention. You may not have the desire to fully commercialize your invention across the whole market. So, for example, geographically, you may say, okay, I've got this great idea for an invention, but I don't have the infrastructure to service, say, the market in unfamiliar territories, say the Far East. But there's nothing to stop you getting a patent in those jurisdictions and then offering a license to a local company who will pay you a royalty of that income that they might make from it. So it's a really good kind of passive income stream then, licensing out. Um, Adding company value. Patents have an intrinsic value to them. They can be bought or sold like any kind of other item of company property. And registered IP adds value. It can attract investment. And there's a link to a survey there about how much more likely companies with registered IP can be to secure funding. However, I suppose that survey, as you can see, was carried out by the European Patent Office and the EU Intellectual Property Office. So I guess they've got a bit of an interest in that finding. Um, Another good reason is reducing your corporation tax. So if you've got a patent granted in the UK, including a European patent which covers the UK, you can reduce your corporation tax burden. The headline is you kind of reduce it to 10% from the other kind of the government figure. Um, in reality, I don't think it's quite that good because there's a few kind of accounting tricks that need to be done. But you can save a lot of tax, and the savings that you make can certainly offset the amount of money you spend on a patent if the profits are significant enough. And interestingly, you only really need a UK patent to take advantage of this. So if all your sales are in the US or you're licensing someone in the US, as long as all the money is coming back into the UK, through your profits as a company and through HMRC, then you can take advantage of that scheme, whether or not you've got a US patent. And obviously make your company stand out. Having patents is quite a sexy thing for a company. So I think Audi did a lot of marketing a few years back on how many patents they had. So it's something that can make you look impressive, make you look at the forefront of technology. So the The next thing I'm going to talk about is, well, what is a patentable invention? How can we show the patent office that we've got something here which is worthy of a patent if that's what we want to do? And essentially, you've got three hurdles, and there are more than this in reality, but these are kind of the three main ones that we concern ourselves overcoming for software inventions. So primarily, um, it's going to be exclusions, novelty, and inventive steps. So the exclusion hurdle is there are some things which the law says are simply not patentable. These are not inventions, and I'll come on to discuss what each of those are. The next hurdle is novelty. It's got to be new. You can't patent something that's old, that's gone before. Um, and it's got to be inventive. So it can't be an obvious kind of development of what's gone before. And again, this ties into that patent deal that I mentioned earlier. So we really want things to go to enter the public domain, which are advancing technology in some way or another. So the exclusions, this is the first hurdle. I've actually put the full well, part of the section one of the Patents Act in here, but the pieces that I've highlighted are the important things, particularly when it comes to software inventions. So, and these are the things that they typically get caught up on. So you can't patent a mathematical method, and you can't patent a scheme, rule, or method for performing a mental act. So simply automating a mental process, playing a game, or doing business, or a program for a computer. Now, what's really important about this section of the Act is the two words right at the end, which I've highlighted, which basically says that you can't patent these things in as much as the invention relates to them as such. And that's really important because it means that the exclusion is not a broad one. It doesn't say that anything to do with computer software is excluded or anything to do with a mathematical method is excluded. It's only when the invention is really focused on that thing. So this is where a lot of people think that there is kind of a blanket exclusion to the patentability of software comes from. But as you'll see, that's not necessarily the case. Not all software is excluded from patentability. So coming on to novelty, essentially, is it new is the question that we're asking here. And I think the important thing to note about the novelty requirement is that your own disclosures can count against you. So this is why patent attorneys in particular are so kind of uptight about, well, have you told anyone about this invention before we file it? Because if you've gone and decided to do, show a bunch of customers your lovely new product and show them how it works, and then thought after that, well, actually, maybe I should get a patent for this. That's not a great situation to be in because it needs to be secret. And I appreciate that's a little bit chicken and egg, because sometimes you don't really know whether your product's going to be, worth the hassle of getting a patent for if you haven't been able to talk to anyone about it. So the way that we get around that is with non-disclosure agreements. So if you're very keen on telling someone about your great new invention, then get an NDA in place, tell them about it, and then that kind of preserves your ability to file a patent application further down the road. And the third requirement is inventive step. So in terms of how the Act defines inventive step, it simply says, well, it's got to be non-obvious to a person skilled in the art. And this person skilled in the art is kind of a legal construct, but it's essentially someone with quite a significant amount of knowledge, but is particularly uninventive. So they can make very simple workshop variations, but they can't take inventive leaps. And there's loads and loads of case law around who that person is and what they know, which I won't go into now. So it's not really the focus of what we're talking about. However, what the focus is can we patent software? So bear in mind those three hurdles. We've got exclusions, we've got novelty and inventive step. And the UK and the European Patent Office actually approach this in quite different ways. The UK, so these are our three hurdles. The UK, typically you get caught up on exclusions. Is it software? Is it a mathematical method? Is it a business method? The European Patent Office, however, have a slightly different way of dealing with it, where they have quite a low bar for the exclusions, to the point where if you're saying, well, it's a software program for a computer or it's a computer implemented invention, that is good enough. It's got a computer in it, therefore it's not just software, is it? Um, and those two exclusions work, in quite different ways, although in principle should have the same result. In practice, they don't. And there's this kind of summed up nicely. This is one of our senior patent judges talking about the difference between the two approaches. And so he's saying that in kind of methodological terms, the approach in the UK and the EPO may look different. In practice, they reach the same result, at least usually. So there's a bit of a caveat to the caveat. Um, to be honest with you, what we find in reality is that you tend to get a slightly easier ride through the European Patent Office because of the way they deal with this type of invention. So if I go through the kind of the way the UK deal with it first, and then we'll come to a bit of case law, and I'll kind of explain, hopefully, with a bit of context how it works. The UK approach is really, as I say, to look at the exclusions. So, and what they say is software to be patentable must make a technical contribution. And that is assessed by something called the Error-Telton-Lacrossen test. And this basically comes from a piece of case law. And what you have to do is you kind of take your claim, and we looked at what the claims are earlier. So it really defines the invention in very succinct terms. Step one is construe the claim. So basically work out what it means. Step two is identify the actual contribution. So what is it contributing to the state of the art? What does the invention actually do? And step three is asking whether it falls exclusively within the excluded matter or solely within that exclusive matter. So if the only advance in your invention falls solely within an excluded matter, so mathematical method, business process, for example, then it's going to be excluded. So if you think you've come up with a really fancy new way of undertaking some currency trading with a piece of software, the new bit, the contribution in that case, is really the trading algorithm, and that is a business method through and through. So it's never going to get through because the advance solely rests within that excluded subject. So the fourth step is really kind of a cross check as to whether it's technical or not. And to be honest with you, the third and fourth steps normally kind of taken together. And obviously, this test ultimately boils down to, is it excluded or is it technical? And generally, things that are technical are not excluded. They're kind of two sides of the same coin. But obviously, that then begs the question, well, what on earth does technical mean? And what we have are some more case law, and this is from a case called AT&T, and it's called the signposts. And these basically help us understand whether something is technical or not. So the kind of the first signpost is whether the claimed technical effect is a technical effect on a process outside the computer. So are you controlling something external? So that the very hackneyed example is if you're controlling a robot arm, that is a very technical process. It is outside the computer. It's in the real world. It's a physical process, and therefore it would not be excluded from patentability, even though the majority of the kind of the calculations, the input, the output is carried out within the software program itself. Another one is whether the claimed technical effect operates at the level of architecture of the computer. So is the effect being produced irrespective of the data being processed? So is it a better computer? Let's say more efficient, for example, or faster? Then that may be a technical process because you are actually, it's within the architecture of the computer itself. Is the computer operating in a new way? So again, it's all about how the computer is working, not just what the software is doing. That may be a technical effect. Does it make it a better computer in the sense of running more efficiently and effectively? And as you can see, there's some overlap between these. So is the computer faster or more efficient, in which case the effect may be technical, which points towards patentability. And the fifth signpost is whether the problem is overcome by the claimed invention or merely circumvented. So you've actually got to overcome a technical problem in order for something to be deemed patentable. And I've got an example of this shortly. So the example I've got from the case law is from a case called Lantana. And what they identified is that if you're trying to retrieve documents from a remote computer, let's say for argument's sake, your computer at home whilst you're in a remote location, and those files are stored locally in that computer. You can use these kind of remote sessions, but a problem is your connection. So it may be unreliable and cause you problems retrieving that data, particularly for large files. So Lantana's invention was simply that you would send an email request to you. I just realised my arrows are the wrong way around. But if you look at step one, the arrows should be going to the right. So you send an email request to this computer via a normal email client. The computer automatically reads that email in some way, understands what you want, and emails the document back to you. And they said, well, this clearly overcomes the problem. It's technical, therefore, can we have a patent? Looking at our Aerotel test, you can kind of summarize the contribution as a computer implemented system for retrieving data from a remote station across a network using emails containing machine readable instructions. And so that's kind of steps 1 and 2. So we've understood what the claim means and we've understood what the contribution is. Now, steps 3 and 4 are whether that contribution falls solely within excluded matter, and whether it's technical or not. Now, we can then look at our signposts for technicality. So does the technical effect have an effect on a process outside the computer or no? It all happens within the computer network. There is nothing going on in kind of the real world, in inverted commas, if you like. So it's not a technical process outside of a computer system at all. It all happens within, albeit two computers network together, but it's still within a computer system. It doesn't operate at the level of architecture of the computer. So it doesn't necessarily make for a better computer. It doesn't result in the computer being made to operate in a new way. It's simply exchanging emails and pulling files. It's nothing new about that. As I said, it doesn't make the computer better in any way. It doesn't run more efficiently or effectively as a computer. And the last signpost is the one where it really fell down. Is actually they didn't overcome the problem. They circumvented it. So they didn't improve the network connection between those two, between the local computer and the remote computer. They completely avoided the problem by using emails to send the request and retrieve the file. So it fell down on that point at 2. And it was actually Justice Burse who made this decision. And in summary, he basically said, in substance, the claim relates to a computer software running on conventional computers connected by a conventional network. The task the software performs moves data from one to another using a conventional technique for carrying out that task, i.e. email. The context in which this arises is that accessing remote computers via continuous connections can be problematic, but it's not a technical solution to those problems. So they're not dealing with the problem of accessing remote computers via continuous connections. They're avoiding the problem using a conventional technique of email. So that was deemed not to be patentable. So we've seen that the UK approach is really to look at, okay, what is this invention about? Does it fall within the exclusions or not? And essentially, you're okay or you're not on that first hurdle. The European Patent Office, as I've said, we get a slightly more patentee friendly approach here in practice. And they don't use, so what the UK uses is something called a contribution approach. Is the contribution technical or not? The EPO, on the other hand, use this approach, which is it's a 2-hurdle test, essentially. So when they're at the first hurdle, which is about is it excluded, they have quite a low bar, as I mentioned earlier. All they ask is, does the invention relate to excluded subject matter as such? We don't start talking about contributions or anything like that. Just what is the invention? So if there's anything in the claim that's not excluded from patentability, it's fine. So essentially, if you've got the words a computer implemented method in claim one of your patent application, you're going to get past that first hurdle. And if you compare that to, the UK approach, obviously it's very different, which is a very high bar, and the EPO have a much lower bar at this stage. Where they differ is again at the third hurdle where we talk about inventive step. And the EPO, you use a test based on a bit of case law, convict, where essentially, if you've got an invention that has a lot of technical features and a lot of non-technical features, as software often does, um, you look at inventive step, but you only really take into account the technical parts of the invention. For all the non-technical parts, they form part of the problem, not part of the solution for you. Um, Again, I appreciate that's probably slightly confusing at first blush, but I'll kind of get into it in a bit more detail. Um, so non-technical features are not taken into account, and a claim in which the only new features are excluded will be deemed obvious because there's no technical effect. So our case study on this one is this is actually from the European Patent Office guidelines, and it's a method of shopping on a mobile device. So what happens is your user basically takes their mobile device and has a shopping list of items. And what the invention is that the mobile device transmits that list of selected products to a server, which I have my laser pointer. So transmits their list, which is here, to the server here. The server goes away and accesses a database of vendors to identify vendors offering at least one of those products. And then the server works out an optimal shopping tour for purchasing each of those products. It does that by accessing a cache memory in which optimal shopping tours determined for previous requests are stored. So it's looking at previous requests, saying, okay, what's the best shopping tool for this? I know it's shopping tool ABCD, and then it sends it back to the user's device so they can go and find all their items. And that's our claim, essentially, which is essentially what I've just gone through. As you can see, it's a method where you've got a user selecting some products to be purchased. Mobile device transmits the product data and device location, and then the server essentially accesses cache memory to work out the optimal shopping tool. So the European Patent Office approach here is to look at the differences. So it passes the first hurdle, which is excluded subject matter. It's a computer implemented invention. We've got mobile devices and servers. It's got technical things in it, so it's okay, even though those technical things aren't new. So what are the differences? Essentially, what we're saying here is that the closest prior art is simply looking at one product and knowing where to find it. So the differences between our invention and the prior art is we're looking up two or more products and we're getting this optimal shopping tour. And the shopping tour is determined by a remote server by accessing this cache memory. And what the Patent Office say is that steps 1 and 2 there are not technical in nature. Selecting more than one product is not a technical process at all. It's simply a requirement of someone that's going shopping. Step 2, having this optimal shopping tour, is also not really a technical problem either. It's simply, a way of carrying out a human activity. The only part of this, which is really technical, is the optimal shopping tour being determined by the server by looking at previous requests. So the way that the European Patent Office deal with that is they say, well, 1 and 2 must form part of the problem. So we essentially end up looking at point 3 and whether that is obvious or not alone. So we're ignoring the non-technical aspects of the claim and only looking at the technical side of things. And under these circumstances, it all really comes down to whether that step of looking up previous requests in a cache um, is inventive or not, or has it been done before? The example the European Patent Office give is that, well, retrieving things from a cache is known. Retrieving tours around locations is a well-known thing to do with a computer memory. Therefore, it's all pretty obvious, isn't it? But you can kind of see how they end up breaking it down to determine kind of technicality and allowability. Just to give you another example of this, this is a process. This was actually in the example that I gave earlier in terms of the claim. And it's a computer implemented method of determining areas whether there's an increased risk of condensation. So what happens is basically you're looking at a surface and you want to know whether this surface is likely to get condensation on it or not. And the way that the invention does this, again, all kind of computer software based, is that you control an infrared camera to look at the surface and capture the temperature distribution across that surface. You send that to your computer. The computer also receives average temperature and humidity values over the last 24 hours and then calculates the mean the mean condensation temperature where there's a risk of condensation on that surface. And then what the computer does is it compares the temperature at each of those points across the surface. And if they're lower than the condensation temperature, it'll color the points in and produce an image saying, well, these areas are your high risk areas for condensation. So when you look at the image, you can kind of see, and obviously, I've done this is a very simple representation, but it could be a much more complex surface that you're looking at. So the question is, well, okay, is that patentable from a software point of view? That's the claim. We don't need to go through that again. We kind of looked it up earlier, but so we will get over the first hurdle again because we've got things like computers, we've got cameras, so there's other things in the claim which aren't excluded, but we still need to know whether we can get a patent on the EPO rules. The step of controlling a camera is clearly a technical step. You're controlling something outside the computer. However, some of the other steps B to E, are all about processing data. They're taking these average kind of temperatures and humidities, comparing them to condensation temperatures, and there's a lot of internal computer processing that are going on. It's all purely mathematical. So arguably they're excluded. Step F is displaying the results, and in the exclusions, displaying information is an excluded piece of subject matter. So again, is it all down to controlling a camera? We have to look at what the closest thing that's already out there is. And let's say, for example, it's a single point temperature sensor result comparing to a dew point temperature. And so the differences are really that we've got an infrared camera, we've got mean values within the kind of calculation steps, condensation temperatures being calculated, and image points having a temperature lower than the calculated condensation temperature. And colors are used to indicate the various different areas here. And the way, again, the European Patent Office calculate whether this is obvious or work out whether this is obvious or not is they're really looking in detail at each of these steps. And as to whether they are excluded. Because, as we said previously, it's only technical subject matter that can contribute to whether the invention is actually non-obvious or rather is inventive. So if you break it down, what the European Patent Office said is that the use of an infrared camera, well, although that may be technical in nature, it's not really new. Infrared cameras are well known, and using an infrared camera to capture a temperature distribution is pretty straightforward. However, what the kind of prior art doesn't suggest is this idea of calculating the mean values in step 2 of the air humidity within the building, calculating the condensation temperature, and imaging those points across the surface to produce this kind of map. Um, and essentially, what they've said is that assuming there's no other prior art that suggests it, there is actually a technical effect here, um, and therefore it does involve an inventive step. Um, so I guess the differences here between the kind of European approach and the UK approach is that you're essentially producing a technical solution to a technical problem over and above, simply looking at, okay, are these steps excluded or not? No, actually, they're all contributed to something which is fundamentally technical. So how this works out in practice is that the UK uses this kind of contribution approach, and the European Patent Office basically treat all computer implemented inventions as technical, but takes a slightly different approach using the inventive step. Um, and then the net result of that is that the UK office can be a bit more dismissive, and in practice, it's more difficult. I think it's fair to say to get computer implemented inventions through the UK office than it is the UPO. The downside to the European Patent Office is it's more expensive. The official fees are much higher. It's a much broader jurisdiction. Potentially, you're getting kind of more for your money because it's a much larger area covering a much larger population. But as you can see, that the two things that the thing that both jurisdictions have in common is the idea of technicality. So software for software's sake is not going to get you through. You need to have something. If you think about those AT&T signposts that the UK use, it's got to be something technical. It's got to be something outside the computer that we're interacting with, something in the real world. Or alternatively, it's got to improve the way the computer works. Does it work more efficiently? Um, even in terms of, say, data transfer across a network, are you improving the kind of the reliability of that connection or something along those lines? Are you making the computer a more efficient thing in its own right? I said at the beginning I was going to talk a little bit about AI as well, which is quite a hot topic. Well, I guess pretty much everywhere at the moment, it seems, but also in the world of patents. Um, you may have heard there's a case which is, as I mentioned, at the Supreme Court at the moment called emotional perception. This is all about artificial neural networks, and essentially the Emotional Perception AI Limited have developed an ANN which recommends music files, or media files like music, based on semantic similarity. So it's more what it is, as the name suggests, about emotional perception as opposed to physical attributes of music. The UK Intellectual Property Office, which is where all this is happening, they rejected that patent application, arguing the invention was a computer program as such, excluded under that section of the Act that we talked about. So again, it fell at the first hurdle. The way that it works, I don't know how much you know about this particular case, but essentially it takes a pair of music files, and what it does with them is there's a couple of things. So firstly, we connected with that music file. So this on music file here, connected with that music file, we have a description, a human description of that file. So it may be a word or a series of words such as happy or sad or jazz or rock, something which isn't necessarily discernible to a computer, but something which, as a human listening to it, you would identify with that music. So if you think about, you can have sad music which transcends the physical kind of definition of music. You can have sad metal songs in as much as you can have sad pop songs. And what happens is the ANN basically takes that description and maps the music in semantic space. In a similar way, it also takes the more traditional route of the physical qualities of the music, such as tone, speed, loudness, and produces a vector in physical space as well. And what I'm going to read this bit out just to make sure I get it right. So essentially, you've mapped your piece of music in two different spaces, two different embedded spaces. And it's the artificial neural network is trained to make the distances between the pairs of the property coordinates converge or diverge in alignment with the distancing between that pair in semantic space. So if the initial physical properties in physical space are quite far apart, if there's a semantic similarity between the songs on the base of the output from the semantic mapping, it'll kind of move them closer together. And that process is done repeatedly. So the result being that the system can provide a single vector in property space, which will have which for any given track of music, it will have a degree of semantic similarity to other music tracks in the proximity of that property vector. So essentially, it's trying to take account of the emotional perception that we have to music, as well as the physical kind of perception, the physical qualities, how they're mapped in space. Um, and the UK office, sorry, the UK Intellectual Property Office said no, you can't have a patent for this. It's clearly just software. It's excluded. However, this was appealed and went to the High Court, and the High Court basically said an artificial neural network, although it's implemented in software, is not merely a computer program. And there are lots of arguments, in fact, about, well, an artificial neural network could be embodied in a physical way. It could be a set of wires, if you like, and resistors and transistors and so on and so forth. So it's not just it's something over and above a mere computer program. And artificial neural networks operate differently from traditional software and involve complex data structures and learning processes. And therefore, the invention makes a technical contribution because it involves processing physical properties of media files. And the output of those files is based on learned semantic relationships, not just metadata or user input. And it goes beyond abstract data manipulation having a real world effect. So this decision kind of, rocked the traditional thoughts around what the exclusions meant to some degree. And the UK office had to update their guidelines to say, well, okay, computer programs are still excluded, but neural networks are okay. We're going to carve out a little exclusion for this. And unsurprisingly, it was appealed again, has now gone up to the Court of Appeal. And the Court of Appeal overturned the High Court's decision and said, no, no, we agree with the Patent Office, and basically said artificial neural networks, whether they're computers or embodied in real life, are still a form of computer. And all the weights and, throughout all those layers are, the parameters of that artificial neural network are still software. And because the invention doesn't improve the function of the underlying computer or solve a technical problem, it's excluded. And merely using known computational techniques to simulate human perception is not a technical effect. So completely disagreed with what the High Court says. And essentially what's happened with this now is after the Court of Appeal decision, this has again been appealed and has found its way to the Supreme Court in the UK. And that hearing has come and gone. And we're simply awaiting the decision on that now to determine whether artificial neural networks are patentable or otherwise. So it's a case of watch this space on that one. But I think the point is that the law is constantly evolving. It wasn't written with things like artificial neural networks or machine learning in mind. So much with other areas of IP law, you may have heard about copyright works being used as training data. It's very very live at the moment in terms of a topic, but it'll be interesting to see what comes out of this particular case. So I suppose. The point I want to make with this slide is not all doom and gloom necessarily. There have been a few cases where things which are implemented by software have been deemed technical in nature. And I thought it'd be good to have a few examples. So we've got a system which automatically generates alerts when inappropriate content is detected. That was a case called Protecting the World, Kids the World Over, which is a High Court case. The technical contribution is automatic generation of an alarm when inappropriate content is detected was deemed to be technical. It was happening outside the computer and alerting people to inappropriate content, and that was deemed to have a technical outcome. Um, Methods for managing touch events on a mobile device, improve user interaction, device responsiveness. So if your invention, has a real effect on how I as a user interact with this particular piece of kit and the touch screen on it, then it may well have a technical effect. Um, Improved image processing has deemed to be technical. So if your software improves the way that images are processed, so improves the speed at which they're processed, or improves image quality, then that's deemed to be technical because it has an effect on physical data. Um, and the final one is all about communication efficiency between computers and servers, um, which was kind of an online collaboration platform using TypeScript, um, which was said to solve a technical problem in a novel way. So there are lots of things within software uh, which have been deemed to be patentable, but it really all comes down to this question of, is it technical in some way? Real world interaction is the key, or does it actually have an effect on the underlying computer? Does it make it more efficient? Does it make it a better computer? Those are the factors that you really need to think about. And as you can probably tell, it's very much a case by case kind of situation, particularly as the law is moving. So, probably going to talk to a patent attorney about it just to get an initial view, um, before you consider going off and filing a patent application potentially. Um, I think the conclusions to all this are, well, some software patent applications, some software inventions are patentable. The UK IPO and EPO have different approaches to this. My personal opinion is that the EPO is more sympathetic towards software inventions, and I think a lot of patent attorneys share that view. But the downside is it costs more to file there. Um, you've got to take the rough with the smooth. And as I said, the technical effect of these inventions is key, and we're seeing that the law is somewhat in flux. I did have got a few more minutes to talk, but well, actually, a kind of a client I was talking to the other day sent this to me, which has happened over in the US, and that at the moment seems to be a whole different ball game, mainly due to the political landscape in the US. Um, but Nintendo have managed to get a patent granted, essentially for some in-game mechanics. The US actually has a kind of a similar legal framework to Europe and the UK, and as much as you've got to have this kind of real world technical effect if you're going to get software through. But it seems to have slid in the other direction a little bit with this particular invention, which is literally talking all about in-game mechanics for a Nintendo Switch. And that's the claim that they managed to get granted somehow. Um, and essentially, as you can probably see, it's all really about how performing control of a moving player character here, and then having a sub character, an enemy character appear next to a sub character, and if he appears too close to him, a battle is kind of initiated. So none of it's really to do with anything happening outside the computer at all, nor is it making it a better or a faster computer. It's simply about how these characters are interacting within the computer game itself, which certainly seems like a good example of something you'd have no chance of getting through in the UK or in Europe. But somehow Nintendo have got that grant in the US. So um, yeah, interesting. So yeah, that's essentially all that I've got to talk about. So thank you very much for listening. I'll if you've got any questions whatsoever, I'm more than happy to take them um, via the chat, I believe. But yeah, thank you for your attention.
Well, has anybody got any questions, please?
Okay, yeah, there's a question just come up there. So is calling something a trade secret a way to get around a non-patentable item? Well, yeah, I haven't really covered trade secrets, so they are kind of the kind of flip side to patents. And they are obviously highly relevant with respect to software. if it's possible to keep something a secret, then it's worth considering that as an option. So, um, if you are able to create software where no one can actually discern how it's working, what's going on under the hood, so it's very black box, then keeping it as a trade secret is absolutely a legitimate strategy. It's something a lot of people do in actually not just in software, but in a lot of other technical arts as well. So if you think about manufacturing or materials, if you know, or even something like I think we mentioned kind of I was talking to a client earlier, and we're talking about well, the Coca-Cola recipe or the KFC herbs and spices, very good trade secrets, although not patentable inventions, but something you can keep entirely secret. Um, trade secrets are a very, highly legitimate way of protecting something. And it's still much like a patent, is a barrier to entry into the market, but just a different type of barrier. So you would have to not just call it a trade secret, but you would treat it as a trade secret. And by that I mean you would need to make sure you've got all the necessary kind of protections and contracts within your company, your undertaking, to make sure that information can't leave. The risk with trade secrets is always going to be that once that cat's out of the bag, you ain't putting it back in. So if you've got a disgruntled employee that decides to take your lovely trade secret and run off to your competitor with it, okay, they may well be breaching their contract there, and you can take action against them. That's all well and good, but the problem is once it's out there, and there's nothing you can really do about it afterwards. So yeah, it's really good question. I think trade secrets are something that's well worth considering, but only for things which you can keep a secret.
I've got a question. If something is pending, and somebody then copies it, and then you get your patent granted, can you retrospectively sue them?
Yeah, so that happens under something called provisional protection. Um, and there are kind of different stages to that. Typically, your provisional protection starts when your patent application is published. Um, and if someone was to start infringing after publication, you can then you kind of claim damages retrospectively, if you see what I mean. So you claim them back to the point at which they should have known um, about the invention. In reality, what happens is that once you're aware that someone's infringing, if you want to start the clock running in terms of being able to claim damages from them, you'd send them a copy. You put them on notice, um, and essentially, once you've done that, they are notified and they've got no excuses. So you then work towards getting your patent granted, and once it is, you claim back damages. Essentially. And that, there is a defense in theory that they could be infringing innocently if they didn't know about the patent. I think in practice it's quite hard to say that in court. And it's impossible to claim that if you've actually put them on notice.
Okay, cheers. Anybody else got any questions?
I have a question, sir. Hello.
Hi.
Hello, yeah, do speak.
So, asking, can someone patent in UK outside or from someone outside the UK?
Yeah, absolutely. You can file a. It doesn't matter where you are in the world or where you come from. You can file a UK patent as an overseas individual or company, or whether or not you're resident in the UK. And in fact, I've got a lot of clients to do. So, for example, I've got clients who are US companies, European companies who file UK patent applications.
Is there a way we can connect more and find out patent in UK? I'm from Kenya, sir.
Okay, yeah, absolutely.
Thank you.
So, another question I've just seen on the chat is if something's patented, is it expensive to enforce the patent? The short answer is yes. Um, if you're talking about court proceedings, it is very expensive. So um, the we have in the UK uh, the Intellectual Property Enterprise Court, which is kind of a streamlined court for SME type litigation, and the that has a cost cap, which means that the maximum amount of cost that you'd end up paying if you lost to the other side is £60,000. In reality, you'd spend a lot more. You know, in the simplest patent cases, you're spending six figures on legal costs. The more complex ones can easily exceed 1 million. So it is very, very expensive, and to be honest, which is why I was kind of talking about all the other advantages of getting a patent, because um, going to court to enforce your patent is not really the place you want to be. What happens in reality, and the vast majority of patent disputes are settled outside court. Very few end up there. You reach some kind of commercial agreement. Um, I've worked with a lot of different companies throughout my career, and it's quite well, it's pretty unknown. I don't think I've ever heard even within the larger companies looking at some patents belonging to smaller companies. I don't think I've ever heard anyone say, "Oh, they're just they're small, or just squash them." People respect patents, so there's usually a commercial deal to be done, which involves a lot less hassle for any size company than ending up in court. And that's normally where patents are really valuable. Is doing those kind of deals and coming to some kind of commercial agreement that works for both of you. Um, I think we've got a raised hand as well from Rich. Is it?
Quick one.
Got his hand.
Oh, hi. Yeah, I just wanted to. It's been brilliant this evening actually, because it's dispelled some of the myth and rumor that I've heard previously around it's just impossible to patent anything kind of computer related. So thank you for that.
No
I was
worries.
speaking to a friend of mine the other day who was asking for advice around filing a patent in Japan. Now, I've been through a patent application. It was unsuccessful, I should say, because of an American pre-existing patent. But anyway, that was a whole different story for a different day. But we went through the European Patent Office route as you did, and then I think is it the Madrid Protocol or something to then move that around the
Madrid's for
world.
trademarks. Yeah, that you're thinking. I think you mean the PCT system, Patent Cooperation Treaty.
Quite possibly, yeah. So that was to move around the world. The guy I was talking to was saying that can be very, very slow, and so he was going directly to Japan and wanted some information on that. Is that your take on it as well? Is it quite a slow process, or is that the better way of achieving it?
Yeah, or to be honest with you, if you use there are different systems you can use and different mechanics to get patents in different countries across the world. And a lot of people use what's called the PCT system, which is the Madrid system's for trademarks, but it's kind of broadly similar in as much as you're filing one centralized application, which is then used to protect in various different countries. Um, the PCT system it does slow things down, but that's kind of its job because the benefit of the PCT, or the two main benefits, are it keeps your costs under control because you're not getting examination reports flying in from different countries in the world. But it also defers the decision for which countries you really want to go for. So rather than saying after a year, okay, you need to make a final decision about which countries you want. What it does is it just allows you to keep your options open. It acts as kind of a placeholder in about 150 countries, and then you don't have to choose them for another year and a half after you file it, typically. So it's a really good, but as a result, it does make things slower. So and yeah, you're absolutely right. If you wanted a patent granted quickly somewhere, you would just file an application there. You just go in directly, or you jump in more quickly via the PCT system. So and there are ways of accelerating these things in all countries. I mean, it is slow for a lot of businesses. So a UK patent will take 3 to 4 years on average to get granted. From filing to grant, 3 to 4 years. Europe could be a bit slower. Other countries can be very, very slow. But you can accelerate those. So I've got UK patents granted in less than a year before. But if you go back to kind of the only real difference is being able to sue someone or not. So the question is, well, why do you want to get it granted more quickly? So inevitably, getting something granted more quickly will compress the costs or raise the costs. Sometimes you have to pay to accelerate. So I'd really be asking what the benefits are for doing that, and they may be they may be kind of legitimate. You may have a licensee who's demanding a granted patent. Otherwise, they're going to pay you some really low royalty. Um, but yeah, you're right. Kind of going direct is often a lot quicker than going slowly. I mean, Japan's a very expensive place to get patents
Oh, right, okay.
anyway, because if you think you've got to translate everything back and forth, so for a start, and attorneys are well paid out there, as you might expect. So can be quite a costly place to get patents granted.
That's great, thank you. And I guess the other thing is, if it buys you that time going through the PCP, sorry, version of it,
Patent Cooperation Treaty.
Thank you. As John just said around the protection that patent pending would give you, by being in part of that process, are you effectively patent pending in all those countries already?
Exactly.
So actually there is
Exactly.
a level of protection already at that point.
Yeah, you get that provisional protection. I mean, you may have to. There may be some funky local requirements that you have to kind of meet. But generally, you are going to be able to put PCT application number on things, which is obviously quite a strong deterrent. I think all the world over, or at least over those 150 odd countries.
Fantastic, that's brilliant. Thank you very much.
You're welcome.
Cheers, Raj. Any more for any more? Kazim seems to have raised his hand. Kazim,
hello,
do you have a
can you hear me?
Hello?
Hi, Kazim.
Yeah, hi. I just want to ask if you're actually working as a team, probably you and your partner, and decide to go into developing a product, and you need to patent it. So who takes full responsibility or claims it?
So do you mean who? So if you're developing something jointly, who would
Yeah,
who would own it?
jointly. Yeah. So who is it going to be jointly patented, or somebody has to take responsibility?
So
Thank you.
it's really up to you. That if neither of you are employed, let's say you're just freelancers or contractors, and you come up with something together. If it's patentable, because you're both inventors, you would jointly own the patent application, and you would typically have one of you would be the kind of representative, or alternatively, you would have a patent attorney who's doing that for you. It's not always the best solution, joint ownership, to be honest with you, because there's no real framework in place for what happens if you fall out or you kind of have different opinions about how things should work. So it is normally better that you have one entity who is the owner, and by entity I mean company. So I think under those circumstances, I'd probably advise that you kind of have a jointly owned company together. The company owns the patent application and eventual patents, and then that then gives you a framework as to how you kind of take the patent forward. You can kind of agree something between you about how that would work in reality. Joint ownership can be quite messy, to be honest with you. So I think putting these things in the name of a company and then agreeing how that company is run is usually the best way forward.
So on the same note, do you advise to register patent as a company rather than as an individual?
Sorry, say again. Didn't quite catch that.
Would you advise to register patent as a company or as an individual?
Again, it's up to you. You can do it either way. I would say it probably comes down to tax benefits, I would think. Um, because the tax breaks you get from having a granted patent only apply to corporation tax. So, a limited company in that case. So that's one factor to think about. The other thing is kind of what is your aim with respect to the invention? Um, if you want to, if your exit plan is to package this up into a nice, neat product, and all the intellectual property is going to be sold off to someone at some point in future, then a company's a neater way to do it. So you would say that all the intellectual property is vested within the company, and then you're simply selling the company. That's more straightforward than if you personally own all those rights yourself. I think there are maybe other reasons to that. If you want to commercialize it, sometimes you want the limited liability protection of a company rather than doing that as an individual. But I think that's probably more a matter of just individual circumstances and looking at all the different factors around operating as a company rather than an individual or sole trader. Obviously, a lot of people set up companies because it's more tax efficient to do so than operate as sole traders. Maybe VAT registration issues or something like that. Something that's a bit beyond my understanding, but I think it's a case by case basis, to be honest.
Thank you.
Thank you for your comments. No, thanks all for listening. I do appreciate it. Appreciate it's not the can be a little bit dry intellectual property law, but hopefully you haven't dropped off.
Well, thank you very much for interesting talk, Phil.
Very welcome.
To stay awake.
Can you share with us the link to the patent page?
Sorry, so I didn't quite catch that.
Can you share the link to the patent page? The link, the web URL to the application patent page.
To which patent page?
The website.
My website is greywolfip.com.